The second panelist, Mr. Mihir Desai, apart from being a senior to me and a guru in terms of legal profession, he's also a senior counsel, mainly practicing in the Bombay High Court. He has been part of several organizations and now the moving force behind the PUCL Maharashtra. Mr. Desai has fought several cases on the issue of prisons and prisoners' rights, including the famous Madhukar Jamle's case, where the court ordered the prisoners have a right to study material inside from books to newspapers and other periodicals. And also a complaint box was started in that case. Recently, he filed a PIL for relief of from the infections for the prisoners and continues to fight for individuals who are behind bars. He has authored the report which will be released by Ms. Daruwala today. We have Mr. Desai who will talk about this aspect and the report also. But I would also like him to address the issue of what is the outcome and what is the of these two PILs. One was the Supreme Court and the one which he filed in the Bombay High Court, and whether he feels in a sense that it helped or it became a kind of a issue that they started using these orders and denying bail to people. Mr. Desai.
Let me start with preliminaries. Normally what happens is that when we have a personal physical meeting, the people who are on the dais, their names are put up on a board, and you know who that person is. You know, I mean, it's put in front of them. Here, I don't think. I mean, most of you know the chairperson, but he goes by the name Street Lawyer. He also has another name that is Vijay Hiri. Okay. And he's a very prominent criminal lawyer and human rights lawyer in Mumbai, and a member of PUCL. So I just wanted to introduce the chair. Having done that, the second thing which I wanted to do was that the report which is being released today will of course be available on the PUCL website from today evening. But apart from that, the entire PUCL team in Maharashtra has participated in bringing out this report, and I would like to thank all of them. And also like to thank three persons, Archana Rupwate, Kritika Agarwal and Isha Khandelwal, for having helped with the cases which ultimately was a trigger for bringing out this report. Having said so, let me just go a little back. Let me start by something which Maya covered, but I just want to cover it in a slightly different way. I mean, she's covered it quite a bit, but in a slightly different way. That, you see, the rights of prisoners, whether prisoners have any rights, that once you are in jail, do you have any rights or all your rights are given a go by, has been something which has been debated in our courts, especially the Supreme Court, since 1950-51, when one of the first cases, okay, which came up, which became again a very controversial case, which was the A.K. Gopalan case, where the question was that a detainee, does he have any fundamental rights once he is detained? Okay, I mean, can his detention be tested on the basis of a violation of fundamental rights? And the Supreme Court at that time had said that no, you can't test his detention on the basis of whether any other fundamental rights with freedom of speech and expression, etc., are violated or not. Okay, so that was what happened in 51. The things started changing in 1966 when you had a case of Prabhakar Sansgiri from Maharashtra. He was a communist. He was arrested. He was detained rather under the detention laws at that time. And he wrote a book while being inside the prison. And that book was called, in Marathi, it was called Anucha Antargat. That is inside an atom. It is nothing to do with atom bomb. Let me make it clear. It was something to do with simplifying the quantum physics theory for young people. Okay? And he wanted to have it published while he was in jail. And the jail authorities said, sorry, we can't publish this book of yours. And the matter went to Supreme Court. And that was the time when the Supreme Court said that you can't stop a person from publishing something. Okay, just because he's in jail, it doesn't stop his freedom of speech and expression. And he can definitely get this book published. And the Supreme Court allowed that book to be published. Similarly, in 1975, you had the Nagbhushan Patnaik case, a very, very prominent Naxalite who was arrested. At that time, in fact, he was sentenced to death. Later on, of course, that sentence was reduced to life, and then finally he was released in 81. But the issue was at that time that the jail and Nagbhushan Patnaik had also escaped from the jail at one point of time. And the issue which it took to the court was that jail authorities were putting live wires on the walls, okay, from where prisoners could escape. Okay. Now this issue came up, and he said that this is, this amounts to death penalty. If somebody wants to escape, the penalty under law is 2 years, but this would amount to death penalty by putting live wires. Supreme Court, of course, did not strike down the live wire thing. Okay, and said that there is nothing wrong with having live wires. Everybody knows that there are live wires. You take your risk, etc. And this is to prevent people from escaping. But at the same time, Supreme Court also said that just because you are in prison doesn't mean your fundamental rights are, other fundamental rights are taken away. Of course, certain fundamental rights would be curtailed, like moving around in the country. The right to freedom of movement and things like that might be curtailed, but that doesn't mean all your other fundamental rights are curtailed. And you still have your fundamental rights, and you have to be treated with dignity. And then you had the period of emergency after that, where everybody knows about the ADM Jabalpur case, which I will not talk about because everybody knows about it. But essentially, what the Supreme Court said is that that people don't have right to life and liberty or right to approach the courts if their freedom is, if their freedom is curtailed. There is another matter which was during emergency, which is not talked about as much, which was a matter called Gaude's matter, Union of India versus Gaude. Okay, in which there were a number of petitions clubbed together. One of the petitions was of Lal Krishna Advani also. He was a detainee at that point of time. And in that matter, the issue was that, look, as prisoners, okay, we may not have right to life generally, but do we not have right to meet our lawyer, meet relatives? Do we not have right to have home food? Do we not have right to buy things from canteen? And the Supreme Court, and this was during emergencies, right? This was immediately after ADM Jabalpur. Supreme Court said, sorry, you don't have any of these rights. Okay, this was just before the emergency ended. But this is also another case where the Supreme Court said you don't have any rights during emergency. Okay, this is also effectively overruled now with Puttaswamy's case, etc., etc. But that was what happened in Supreme Court. Now, what happens after the emergency is we all know that there is a beginning of the public interest litigation regime which starts. And that public interest litigation regime starts, if you see the cases in the 70s, late 70s, when it actually begins, starts with most of the cases pertaining to prisoners. Okay? There is a Charles Sobraj case, there is a Sunil Batra case, there is Husainara Khatun case, there is Francis Mullian case. There are various cases where the Supreme Court, especially through Justice Krishna Iyer, Justice Bhagwati, Justice Mihir Desai, etc., lay down very, 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 they very, very strongly say that prisoners, just because you are prisoners, you are not denuded of your rights. You can't be put in iron fetters. You can't be given additional punishments when you are in prisons. You can't be put in solitary confinement just because the prison authorities want you to be. You have a right to meet your family members. You have a right to meet your lawyers, etc., etc. And from that time onwards, there is a growth of PILs and PILs pertaining to prisoners' rights. And that's how in fact the PIL regime begins in the country, through prisoners' rights. Letters are taken as petitions, etc. All that thing starts in 70s, and that continues till today. Okay, it continues until today, where the Supreme Court and also various high courts have intervened from time to time to say that prisoners are not denuded of their dignity, of their rights, just because they are prisoners, and they have every right within the prisons, okay, to all the facilities which they would otherwise have if they were not prisoners, barring certain curtailment of civil liberties, which includes a right to fair wages if they are asked to work, which includes right to not to be in solitary confinement, which includes right to speedy trial. Now, I am not right now speaking about how much are they implemented. okay, which is a separate issue altogether. But what I'm saying is that, therefore, by the time we come to the COVID, because right now I'll be talking much more about COVID. Once you come to the COVID situation, okay, you already have a situation whereby there is a 40-year jurisprudence of the Supreme Court and of the various high courts, which says that prisoners have a large number of fundamental rights which they retain while being in prison. And those fundamental rights have to be protected and supported. This is the jurisprudence which exists when COVID starts. Okay. Now let us look at a little bit about what happens once COVID starts. Okay. Once COVID starts, you have the Supreme Court. And this is one thing, I mean, one is highly critical of Supreme Court's role during the COVID times. I personally am. But I must mention that on 16th March 2020, Supreme Court takes the first suo moto action as far as COVID is concerned, and that's concerning prisons. Okay? So it issues notices to all state governments and the central government saying that you must decongest the prisons. Okay? And on 23rd March 2020, a detailed order is passed. Now that order says two things. Okay, Maya referred to it. I'll just elaborate a little bit on it. It refers to two things. It says, one, that state governments must have high-powered committees which are set up. Okay, those committees must look into the issue of decongesting prisons immediately. And one of the examples given by the Supreme Court was that those under 7 years, for instance, whether they are convicts or whether they are under trial, those who are charged with offences which will lead to a punishment of less than 7 years, should be released on temporary bail or parole. That is what the Supreme Court says. Okay. Now, after that, there are two other things which the Supreme Court says in the same order. One thing they say is that from now onwards, physical meetings of relatives and lawyers with the prisoners will be stopped. And second thing is their presence, the prisoners will not be presented in court. This is one thing they say, the Supreme Court says. And the other thing they say that every state government should have a monitoring committee set up in order to see whether the conditions of prisons are proper or not. This is what the Supreme Court says. Okay. Now let us look at what is the situation in Maharashtra. And what, as Maya said earlier, the situation in Maharashtra is only an example, okay, of something which is happening across the country. Maybe in many other states, the situation is much worse. Okay. Maharashtra has totally 60 prisons. Okay, 60 prisons. On 31st March 2020, the capacity of the prisons, the total capacity of the Maharashtra prisons was 24,032. That was the capacity. Okay. The total number of persons who were inside at that time, who were in the prisons, were 36,061. Okay. So you have a capacity of 24,000 and 36,000 are the number of prisoners who are actually incarcerated at that point of time. Out of these 36,000, 9,000 were convicts. That is about 25%, and 26,762 were under trials. So 75% of the persons who were in prison were under trials at the time when 31st March. So you have, just imagine the situation that 75% of the people, okay, are inside the prisons in Maharashtra on 31st March 2020 who are yet to be even found guilty. Okay. These are the kind of people who are there. And we are in a constitutional regime of presumption of innocence. But you still have 75% people who are inside and who are under trials. Okay? And I need not say it, but an overwhelming majority of these people are poor, marginalized, belonging to either the Dalits or tribals or minority communities, etc., etc. So that was the situation. On 25th March 2020, you have the High Power Committee of Maharashtra sitting and saying that we will let the prison authorities see. What happens is that if you are a convict, okay, you have to apply for what is known as parole. Okay? And if you are under trial, you have to apply for bail, temporary bail. Okay? Parole is given by the prison authorities, bail is given by the courts. Okay? So the convicts, so the High Power Committee said, let them, those who are under 7 years, okay, which was an example given by the Supreme Court. Those who are under 7 years should be should either apply for parole or should apply for bail, and they should be, as far as possible, try to decongest. That is the kind of an order. They made, of course, exception in various cases. Like they made exceptions for all special laws such as UAPA, MCOCA, then PM, then Money Laundering Act, and various other acts. They made exceptions and said that these people cannot be released. Now, there was a fallacy in this whole reasoning, because the fallacy was this, that the idea was to release people who are above a particular age, that is, say, above 60 years, and also release people who have comorbidities. Idea was not to release on, because this is temporary release. This is not a permanent release. This is not a permanent parole or a permanent bail. Okay? So the idea was to let people out who are suffering from comorbidities or suffering from this kind of age related, or they are above a particular age, which was what was accepted at that time as a reason, okay, for being more susceptible to COVID. Okay? But this was not done. What instead happened was offense became the criteria for deciding whether you should, put a person or you should release a person or not. So anyway, this was what was done. Now, what happens? Various petitions are filed in the court, in the High Court. Various petitions are filed. One by PUCL, by some other persons also, they filed petitions. And the court asks the government to give a status report. Okay. And what we realize is that despite this order being passed on 25th March 2020 by the High Power Committee, despite this recommendation, on 19th June 2020, out of 36,000, only 8,000 are released. So you have about 29,000 prisoners. Okay, on 19th June 2020, okay, 29,000 prisoners, when the capacity itself is 24,000. And please remember, the state government also made an affidavit in the court that while the prison capacity is 29,000, 24,000, prison capacity is 24,000. If we want to maintain social distancing, because this prison capacity is on the basis of non-social distancing formula. But if you want to maintain social distancing, then we should bring it down to 16,000. This is what they said. But despite the orders of the high-powered committee, and despite from time to time people making applications, about 12,000 applications for bail were filed, 14,000 applications for bail were filed. Despite that, you have a situation whereby 29,000 people are still in jail. Okay, this is in addition to the temporary jails which were created outside the normal jails. About 39 temporary jails were created outside the jails, where people would be put in quarantine. New prisoners would be put in those prisons, etc. There are 39 additional. We don't know till today how many people are in those jails. So this was the situation. Okay, and this continues to be situation that you have a very, very, very large amount of congestion even still existing till today. And one of the reasons being that the courts, when temporary bail applications were made, instead of deciding on a basis whether for temporary period they should be allowed to be enlarged on bail, went into the actual merits of the case. Okay. And started deciding the matters on the basis of merits, and did not grant anybody, did not grant to a large number of people bail. So people continue to remain inside. This is one thing which happened. Okay. The other thing which happened, okay, is that while the prison authorities, because they run the prisons, sorry, while the prison authorities were keen, at least certain prison authorities were keen to release, to decongest the prisons. Okay. Parole, that is for the convicts, paroles were granted on a large extent. Okay. Because that is granted by prison authorities, while bail for under trials are granted by the courts, Okay, so you have substantial number of convicts being released, while a large number, overwhelming number of under trials being still within the prisons. This is what this is the situation. Okay, which has happened, and despite, and there was another petition filed after this petition was disposed of with certain directions. Another petition was filed concerning why are you making this categorization? Okay, this was filed by the National Alliance of People's Movement, NAPM, and Medha Patkar. That why are you allowing? Why are you making this distinction between this kind of offense and that kind of offense? Look at their age, look at their comorbidities, and then release them. And that petition was dismissed by the Bombay High Court, okay, saying that we can't get into all this. Okay, so that was a situation. So the first issue is about decongestion. The second issue concerns the spread of COVID, okay, within the prisons, and what did they do to prevent the spread? Okay, so you have this congestion. You also have, for instance, on 10th May 2020, more than 100 people, okay, in Arthur Road prison, okay, being detected positive, okay, being detected positive in Arthur Road prison in Mumbai. Now, Arthur Road prison in Mumbai has a capacity of 804 prisoners. Okay? It's the main prison, one of the main prisons in Maharashtra. Okay? It has a capacity of 804 prisoners. Okay? It had at that time the occupancy of 2,800 prisoners. Okay, for a capacity of 804, you had an occupancy of 2,800 prisoners. Okay, that was the situation in May 2020. Okay, so you had about 108 prisoners being detected positive. In court, when we raised this issue, okay, that not only in Arthur Road but in various other prisons there are prisoners being detected positive, and what are you doing about it? Okay. Finally, the state government filed an affidavit. In the affidavit, the state government says that 4 prisoners have died due to COVID, and we realized they had COVID only after they died. Okay, so it was not even a case where they were tested, found positive, given treatment, and they died. It was a case where no treatment was given. People were found positive after they died. Okay, that was the situation. So then the question came that and it was not just the prisoners who were affected, it was also the staff, the prison staff, which was being affected. Okay? And if you see the all India scenario, I mean, you have had a situation where Anantnag jail in Jammu and Kashmir, okay, where 50% of the prisoners were found positive. You had in Guwahati, okay, jail where a large number, about 900 prisoners were found to be positive. So you have, this is not a scenario only of Maharashtra. You have this scenario across the country. So the other issue which really comes up is what is the kind of testing you are doing. Okay? Whether you are doing enough testing, you are not doing enough testing, what is happening? And the answer was, and the answer still is, that we are not really concerned with testing everybody, because our demand was you test everybody. So they said, okay, we have started taking everybody's temperature through the thermal thermometer on an everyday basis, but that really it doesn't show you whether you are positive. So then we said, okay, you at least test people, give a swab test to everybody once regularly, because prisons are confined places. If somebody gets positive, it's bound to spread very, very fast. The answer was no, we can't test everybody together. So, as Vijay also mentioned earlier in his introduction, we had to file cases, individual cases, and look at this is the example I would like to give you. Varavara Rao, everybody knows, okay, was in prison, was in what is known as Taloja jail, and he was in Taloja hospital, okay, Taloja jail hospital, okay, in the prison hospital. Along with them was Vardhan Gonzalez and Anand Teltumde, who were also in the hospital. Vardhan was not hospitalized, but he was asked to take care of Varavara Rao. Okay? And Anand Teltumde was in the hospital, okay, in the jail hospital. So he was occupying a nearby bed in the jail hospital. You also had Mahesh Raut, who was in the hospital. Okay? Now, Varavara Rao was thereafter taken out. We all know about his story. He was taken out. He was declared positive. Then he was treated in Nanavati. Now he's being discharged, etc., etc. He was, and that too also happened because of a huge public pressure from outside. But once Varavara Rao was detected positive, these people said, you test us because we were there 24 hours with him, with Varavara Rao. You must test us. They didn't test. So we went to court. Okay. So Mahesh Raut goes to court, Vernon Gonzalez goes to court, Anand Teltumde goes to court, and look at the situation. Okay, and this is what I want to really harp on. Look at the situation. What happens? Yeah? Anand Teltumde and Mahesh Raut, both of whom I have met, of course. Okay, if you ask them to stand together, you will not mistake one for the other. Okay, Anand Teltumde is a relatively taller person. Mahesh Raut is not so tall. The weight of the two persons differs considerably, even now in jail and even earlier. Okay, so so when we go to court, court says, okay, show the reports. Okay, so Mahesh Raut's report and Anand Teltumde's reports are brought. They are supposed to have been tested, okay, at some stage, and those reports are identical. Okay, for instance, Mahesh Raut is shown as 153 centimeters tall. Anand Teltumde is shown as 153 centimeters tall, while Anand Teltumde is 180 centimeters tall. Okay. Mahesh Raut is shown as weighing 57 kilos. Anand Teltumde is shown as weighing 57 kilos, while Anand Teltumde is 78 kilos. Okay, he weighs 78 kilos. Okay. Blood pressure same, oxygen absorption same, all kinds of every test. Identical results. It was, and the state government had to admit in the court that there has been some copy paste problem with us. Okay. Now this is the kind of testing which is happening in jails. When they copy paste one person's report onto another person's report, and this happens when they are asked by the court, by the High Court. So just imagine what must be happening when there is no court supervision. What kind of reports they must be coming out with, what kind of tests they must be doing. This is so we had asked the court that let everybody be tested. Okay. So the court said, no, we can't ask, we'll ask them to do random tests, etc., etc. So the court ordered that they should do random tests and they should test everybody who has some kind of a symptom. Okay. That if you have symptom, you test. Okay. So this was so this is as far as testing is concerned. Okay. The third issue, okay, which is of staff, and which Maya mentioned elaborately about the staff. So just about Maharashtra, I would say that there is sanctioned vacancy. There is a sanctioned strength of 175 health workers across Maharashtra jails. Okay, 175 health workers are sanctioned. This includes doctors, nurses, etc. Presently, there are 63 vacancies. Okay, so our demand was you fill up these vacancies. You have 63 vacancies. Okay, you must fill up these vacancies. That was the demand. That has, of course, not been answered. They have not filled up. The other issue was, of course, about personal visits. Because remember one thing: whatever data we get from the prisons, or whatever data I have been telling you about, okay, is not because the prison authorities declare this data. Okay, either this data comes across because there is some leakage in the press, and the press publishes it, and so we come to know about it. Or if a matter is going on in court and the court asks them to give a status report, okay, they bring a status report and you come to know that these are the number of people who are infected. Okay, so there is no way for anybody to know today how many people are infected, except through some press release, and not every time there is infection you will get a press release. Okay, or you will have because what we have been hearing is that more than 1,000 prisoners, okay, and staff at least are infected as of today in Maharashtra jails. But the exact details are not known. Okay, nobody knows the exact details because not enough tests are being done. We don't even know whether proper tests are being done. And even if those tests are being done, there is no public announcement. They have a website, but they don't put on the website as to whether these tests are, or what is happening to this test. So this is the other thing which is happening, that you have a complete non-transparency. Okay, as far as the prisons are concerned, and please understand one thing, that in normal times, what happens is that prisoners meet their relatives who go to visit them in prisons, or prisoners meet their lawyers or relatives either in prison or in court when they are regularly, at least under trial prisoners are regularly produced. Okay, so they meet the lawyers, they meet the relatives, and they are able to transmit the information. Okay, what is happening inside the jail. Okay, this is what happens. Now there are no prison visits allowed. Now there are no court visits allowed. So there is no way in which a prisoner can transmit information as to what is happening inside. Now, what is allowed? Okay, because that's what we had said, that way back in 1981, the Supreme Court had said that in Francis Mullien's case, that prisoners must be allowed, whether the rules say so or not. Every prisoner must be allowed at least 2 visits per week of at least 20 minutes. Okay, this is what the Supreme Court says in Francis Mullien's case. Okay, so 20 minutes, at least 2 visits per week. Okay, in the prison. That is what the Supreme Court lays down. Okay. Now what is allowed? Prison visits have stopped. Court visits have stopped. Okay. So what they came out with is, we'll allow people to speak on telephone. Okay. And what has happened is, the reality is that once in 15 days or something like that, a prisoner is allowed to speak to his or her relative for 2 minutes. Okay, that's what is happening today. For 2 minutes, they are allowed to speak. And you see, the phone is with the jail authorities. So jail authorities are present when they speak to their relatives, etc., outside the prison. So they are being constantly monitored and censored as to what they are speaking. Okay, so people are also scared of saying whatever they want to say. So that's a situation which is so there is no way in which the communication from behind the fortresses of prison is coming out. Okay, so now this was the case even earlier, even before COVID times, and there were cases filed in Supreme Court, in Bombay High Court, etc. And the High Court, for instance, in 2017, through a judgment of Justice Oak, had recognized the fact that prisoners have become like fortresses, and there must be surprise visits by social workers and also by teams of the government, okay, who make surprise visits to prisons in order to ensure that all the directions concerning prisoners' rights are complied with. So you had surprise visits. Now those surprise visits have stopped. So there is nobody visiting, going inside the prison to find out what is happening in the prisons. Nobody is allowed to go in. The social workers are not allowed to go in, lawyers are not allowed to go in, no committee is allowed to go in. Okay? So that's the situation where the prisoners, where it's a completely an opaque system, okay? Where the only thing you rely on is some prisoner who is released on bail at some time to try and talk to that person to find out what is the situation in the prison. Otherwise, there is no way of knowing what is happening in prison. So that was the other thing which we have been demanding. That you must have transparency, you must have your websites on which you publish on a daily basis the number of prisoners, the number of under trials, the number of tests conducted, the number of results. We don't want the name of the persons who has been tested, because that would be breaching confidentiality. But we do want want all those details to be done on a daily basis. So that's the other thing we are asking. And we are saying that every person should be allowed to make phone calls for at least 10 minutes. Okay, twice in a week, once to the relative, once to the lawyer, because otherwise, how do you communicate with outsiders? So that's the other thing which we have been strongly demanding and asking for. So what our report basically delineates, what our report basically speaks about, is these conditions of prisons which are presently prevailing in Maharashtra during COVID times. Even in non-COVID times, the conditions of prisons are bad. But in COVID times, they become life-threatening for people who are not even sentenced to death. It becomes life-threatening for people. People have been dying. And this has been happening across the country. We thought we'll take Maharashtra as an example. One of the reasons being because of the court cases which were filed, certain status reports were filed in court. Okay, so all those status reports have been are shown as part of our report which we have come out with, and our demands are very clear. Our demands are to decongest the prisons. Our demand is to start, allow people to have telephonic talks. Our demand on a regular basis for at least 10 minutes each every week, twice a week. Our demand is to allow people, social workers, our demand is to allow the civil society organizations to visit in a surprise manner the prisons to see what the conditions are. Our demand is basically to provide health and sanitation to prisoners. Because the other thing which is happening is because of this COVID, because a lot of prisoners have health problems. It's not just COVID related problems, they have a lot of other health problems. And those health problems are being completely sidelined because everybody is focusing on COVID and the other health problems are being sidelined. For instance, many of the prisoners say that we have blood pressure problem, we have diabetes problems, our medicines are not coming because people are not allowed to come in, our medicines are not being sent. All these kind of problems. Okay, so prisons have really become hell houses right now. Okay, they were earlier also, but they have become real hell houses now. And I personally feel unless immediate, and this COVID situation, as Vijay also mentioned, can last for God knows how long, how many months, years, we don't know. Okay. So yes, the courts also should be started. The courts must start. And there is nothing wrong if the judges go to jail also and hear matters. Let them do that if they have to do that. It has been done in the past. It is not a new thing which is happening only during COVID times. These are things which have happened in the past. So let all these things, let there be meetings, let there be surprise visit, let the decongestion guidelines be changed in order to allow all those above 60 years and all those with comorbidities to be released. You put conditions on them, you check them, but release them. Okay? Let there be regular testing, and let similar conditions as are required to be in prisons, okay, be also maintained in the temporary prisons which they have set up, because these temporary prisons are another hellholes where people are cramped to capacity. We know of the case of Gautam Naulakha, who was put in a temporary prison for initially when he came. And the situation was very, 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 very serious in the temporary prisons because 350 people are cramped in one or two small rooms with 2 bathrooms, etc., etc. So you can't maintain either social distancing, you can't maintain hygiene, you can't maintain health, nothing like that. So that's the other thing which we have asked for, that the quarantine centers and the temporary prison should also maintain the same standards as are required to be maintained by the prisons. I think I'll stop there. Thank you very much.